over. So I will request all of you to please communicate others to join through our YouTube link. So before start of the program, with the permission of all of you, can we have 2 minutes silence? 2 मिनट का मौन रखेंगे जो हमारे चार्टर्ड अकाउंटेंट्स और उनके परिवार के सदस्य इस कोरोना पैंडेमिक की वजह से अब हमारे बीच नहीं है। उन दिवंगत आत्माओं की शांति के लिए परमपिता परमात्मा से प्रार्थना करेंगे। ओम शांति 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 शांति। I think Rakesh ji, we can start.
दोस्तों नमस्कार, मैं सीए राकेश वाट्स ने जवाहर पार्क की तरफ से आज के हमारे गेस्ट स्पीकर सीए राजीव आहूजा जी और हमारे चीफ गेस्ट सीए अनुज गोयल जी का हार्दिक स्वागत अभिनंदन करता हूं। आज का प्रोग्राम शुरू करने से पहले मैं श्याम अग्रवाल जी से निवेदन करूंगा कि वो आए और आज के प्रोग्राम के बारे में और सभी लोगों का स्वागत करें।
Thank you, Rakesh ji. Good evening to everyone. I, Shyam Agarwal, convener of Johar Park Chief Study Circle, welcome to all. Now we have with us CA Anuj Goyal ji, our Central Council member and Chairman for CMI IPC Committee. I heartily welcome to Anuj ji. Now we have with us our next speaker, Sri Rajeev Ahuja ji, on the topic of insight of faceless assessment and appeal.
Rajeev ji, you please stop screen sharing. Rajeev ji, please stop screen sharing.
I heartily welcome to Rajeev ji. I also welcome our participants and viewers. Now मैं request करता हूँ वासने जी से क्यों
बहुत-बहुत धन्यवाद श्याम जी। श्याम जी, आप राजीव जी का आपके पास कुछ बायोडाटा है क्योंकि नरेंद्र ओझा नहीं आए हैं अभी तक। श्याम जी,
I will introduce Advocate CA Rajeev Ahuja ji. Rajeev Ahuja ji, we are having the presence of CA Narendra Oza ji, our Deputy Convener of Jawahar Park CP Study Circle. So I will request CA Narendra Oza ji to formally introduce our honorable resource person, our honorable guest speaker, Advocate CA Rajeev Ahuja ji. CA Narendra Oza ji.
2 मिनट सर, आप बोल लो अभी।
Yeah, and Rajeev Ahuja ji is a very prominent chartered accountant, and now he is practicing as an advocate in the field of direct taxes. He is practicing at Delhi and is representing the assessees at High Court and Supreme Court level also, and Income Tax Appellate Tribunal also, and is contributing like anything as a resource person, as a guest speaker. And he basically belongs from Meerut, and now he is residing at Ghaziabad. So practically he is contributing in Delhi NCR, and a lot number of chartered accountants are also taking the services of the Rajeev Ahuja ji. So I welcome honorable guest speaker, Advocate CA Rajeev Ahuja ji. Over to CA Narendra Oza ji.
नरेंद्र भाई।
राकेश जी, you can go ahead.
बहुत बहुत धन्यवाद अनुज जी हमारे गेस्ट स्पीकर्स के बारे में बताने के लिए। जैसा कि हमारी परंपरा है कि हम अपने अतिथि का, जो हमारे चीफ गेस्ट होते हैं, उनको स्वागत करते हैं। तो उसके लिए एक मैं स्वरचित एक 4 लाइनें मैंने लिखी हैं, वो आपके सम्मान में मैं पेश कर रहा हूँ। स्वागतम स्वागतम स्वागतम, हम करते हैं अनुज जी आपका स्वागतम। आपका आना यहाँ खुशियों का मेला है, अंधेरों से दूर आज रोशनियों का रेला है। हम पे हुआ उस अनदेखे खुदा का करम, हम पे हुआ उस अनदेखे खुदा का करम। स्वागतम स्वागतम स्वागतम। आज महफिल हो गई है जमा सारी, संग भाग के आपकी तलवार है दुधारी, मन पंक्षी उड़ता रे छूले आसमां गगन। स्वागतम स्वागतम स्वागतम। आपका बहुत बहुत स्वागत, तहे दिल से स्वागत। ये हमारे जवाहर पार्क का सौभाग्य है कि आपका सानिध्य और आपका आशीर्वाद हमेशा शुरू से ही जवाहर पार्क को मिलता रहा है, और मैं आशा करता हूं कि आगे भी इसी तरह से आपका प्यार और आशीर्वाद मिलता रहेगा। अनुज जी के बारे में कोई भी चीज बताने से पहले एक सूर्य को दीपक दिखाने के समान है कि उनके जो फैन फॉलोअर्स हैं, जो उनके चाहने वाले हैं, वो उतने ज्यादा हैं और बहुत अच्छी तरह से उसके परिचित हैं। लेकिन क्योंकि फॉर्मेलिटी है तो उसके लिए मैं एक इनका ब्रीफ बायोडाटा में पढ़ रहा हूँ। सीए अनुज गोयल जी इज सेंट्रल काउंसिल मेंबर ऑफ द इंस्टीट्यूट ऑफ चार्टर्ड अकाउंटेंट ऑफ इंडिया ICAI with this 14 years experience in council, 13 years in regional council and 6 years in branch. He contributed immensely in various capacities. Presently, he is the chairman of the research committee, the oldest committee of the ICAI. Capital Market and Investors Protection Committee of ICAI. He is also the vice chairman of the Corporate Laws, Corporate Governance Committee. With the exemplary academics, he possesses the CA, CS, CMA, ICWA, LLM, MCOM, visa and DIRM. बहुत बहुत स्वागत अनुज जी आपका। अब मैं अनुज जी से निवेदन करूंगा कि अपने वर्ड्स ऑफ विजडम एक हमारे साथ में रखें, अपने विचार हमारे साथ रखें। ओवर टू अनुज जी।
Thank you, CA Rakesh Vaste ji, the founder of Jawahar Park CP Study Circle and very prominent social worker who is contributing not only for the profession but also for the society in a great way. We are having, of course, the presence of our honorable resource person, our honorable guest speaker, CA turned advocate, none other than Rajeev Ahuja ji, who is going to take very important session for all of us inside of faceless assessment, appeals, tactical approach. And of course, we are having Deputy Convener, CA Narendra Oja ji, who is contributing like anything for the cause of the profession. So very good evening to all our honorable learned professional colleagues. Friends, I am really very happy that in this corona time also, in this pandemic also, I think it is the biggest threat which we have seen for the mankind in the recent past. And our chartered accountants have converted this threat into a opportunity by updating their knowledge on day-to-day basis. And through that, we are not only enriching our knowledge, but also in turn, it would be good for the profession and for the nation. And the most important benefit of that is that we will be away from negative thoughts and negative news, which is there everywhere in this corona pandemic time, whether it is social media or news channel. So we are trying to see that how we can have more and more knowledge enriching virtual programs so that we can be busy in these knowledge enriching activities. I welcome C. Syam Agarwal ji, our honorable convener of Jawahar Park CP Study Circle, and all the delegates. I think our Zoom platform is full. 500 capacity is there. I will request all the delegates to please communicate others to join through YouTube link, which is there on the chat box. I have already pasted it in the chat box because we are having more than 1300, 1400 registrations. So all others can join through YouTube link. Friends, it is rightly remarked, the education is the most powerful weapon which you can use to change the world. I'm delighted by the efforts made by the Jawahar Park CP Study Circle to organize the virtual CP seminar for dissemination of knowledge and insights of practical approach on faceless assessments and appeals. And friends, I know that there are always the teething problems, and there is always resistance to change. Even the chartered accountants who are dealing in this physical assessment and appeal system since last 20 years, 30 years, or 40 years may be finding it difficult to cope up. But I think the real role of the chartered accountants, who are the best accounting professionals across the globe, is in the corruption-free system only. I think our knowledge, our dedication, devotion, commitment will be best utilized when there is corruption-free system. So this faceless assessment and appeals will provide us an opportunity to show to the outside world, to the department, to the trade and industry, to the government, that how competent the members of the Institute of Chartered Accountants of India are. Friends, the central government introduced the faceless assessment scheme to provide greater transparency, efficiency, and accountability in income tax assessment. All the provisions under faceless assessments introduced to eliminate the interface between the assessing officer and the assessee during the course of proceedings, to optimize the utilization of resources through the economies of scale and functional specialization, and to introduce a team-based determination of arm's length price with dynamic jurisdiction. मुझे लगता है कि गवर्नमेंट को पहले से ही पता था that this type of pandemic may be there, and due to that reason they were ready in advance with the faceless assessment and faceless appeal system. Friends, this has been the greatest and the revolutionary change as far as income tax is concerned, where the entire assessment will be done with the help of artificial intelligence and data mining. Therefore, it is going to completely transform how we have been doing our income tax assessment and how we have been handling income tax cases. The revolutionary change in the Income Tax Act is going to give us a lot of new challenges, but we must always remember that along with new challenges comes several new opportunities also. And the new generation of the chartered accountants will now be very, very important for all of us. Every office will now need the newly qualified chartered accountants who do have the command on the technology and who can use the technology and can help out our office. If we have to handle this revolutionary change, we must all be updated, and updating ourselves on the various issues has become a tremendous task. And I really appreciate the efforts of Jawahar Park Study Circle for organizing the virtual CP seminar to impart knowledge on faceless assessment and appeals, and to demonstrate the practical aspects and nitty-gritties of the manner of conducting faceless assessments. I would like to convey my best wishes for this very, very productive session. Friends, as I conclude, I will once again request all of you to see that how we can be at our home, how we can be safe, how we can try to have the vaccination not only for ourselves but also for our family members. ICAI is trying its level best to have the vaccination drive for the chartered accountants and their families everywhere, whether it is Delhi, Ghaziabad, Noida, or other parts of the country. So please have the vaccination at the earliest, so that we can fight this corona pandemic in a very, very effective manner. So without taking your further time, I once again welcome all our honorable delegates from each and every part of country. And I will request all of you, because our Zoom platform is full, so please communicate others to join through YouTube link, which has been given in our chat box. So you can communicate that YouTube link to others so that they can join this very, very important session through YouTube channel also. Thank you very much. Over to CA Rakesh Vastage.
बहुत बहुत धन्यवाद अनुज गोयल जी आपके मोटिवेटिंग वर्ड्स के लिए। अब ज्यादा समय न लेते हुए मैं हमारे आज के स्पीकर से मैं निवेदन करूंगा कि वो आए और अपने व्याख्यान को सुने। सीए राजीव आहूजा जी।
धन्यवाद राकेश वार्ष्णेय जी, अनुज गोयल जी, डिप्टी कन्वीनर ओझा जी और श्याम अग्रवाल जी। thank you very much for providing the opportunity to interact with the members of the study circle and other persons who are interacting, viewing this on the YouTube channel. Today's topic, which we have decided, is faceless assessments and appeal and ITATs. Recently, in the Finance Act 2021, the government has also proposed the faceless ITAT, which has been put on hold as of now, but which is a coming future. We all seeing the VCs are going on, courts are working on virtual mode. So this is again a very good opportunity for all of us. But what is the criteria? What is the change in department? Here in my presentation, I will cover that what are the areas which are there, how the structure has been created. We'll try to explain to all the members. Earlier, we have seen the ITOs, ward, then range heads, circle heads, chief commissioners, principal commissioners. The basic scheme is no human interface. Anuj in his introduction clearly mentioned there would be a data mining and artificial intelligence. In a common layman language, if I would like to explain the difference of the two, what is automation and what is artificial intelligence? We have seen the computer programming in a very basic term. I would like to explain it, that in a computer language, what has been taught to the computer? 2 plus 2, 4, 5 plus 5, 10. Whatever logic has been created, the computer acted on that. It's a vast logic has been created. But if something new has to be given to him, he put an error message. I don't understand it. So in a logical programming, computer does not go beyond what the logic provided to him. But in artificial intelligence, what has been taught? I will give a basic example. When a guest comes to our house, our kids, we welcome them. Our kids learn that what we are doing. So when a guest comes and we are not there, our kids welcome that. What they have done, they have learned that how we behave in a particular situation and circumstances. So artificial intelligence does the same thing. It creates the logic, develops the logic based upon the situation coming to them. So that is why it is called artificial intelligence is being put into the system. We all know that government, that income tax department is having a huge and vast data with them. Now, if based upon that huge and vast data, logics are being created to make it more mining. Now, artificial intelligence put into place. So that is where no human interface and the department would be functioning with the use of the artificial intelligence. How where they will apply, we'll discuss in the later part of the presentation. The first of all, this scheme is launched in 2019. First of all, in a phased manner. In August 2019, PM has come and said, okay, now everything is going to be faceless. Commissioner appeals and the assessments. All the notices has to be issued electronically by a central cell. There would be no face that who is issuing the notice. There will be no face of the person who is issuing the notice. The central cell would be a single point of contact between the taxpayer and the department in order to achieve the ease of the compliance for the taxpayers, to bring the more transparency and efficiency in the functioning of the tax department, to use the functional specialization of the resources available with the tax department. The benefit is to have the improvement in the quality of the assessments. Assessments will be completed with a risk-based and focused approach, systematic and specific verification, standardization of the processes and quality management. And last but not the least and very important, the better monitoring. What we have seen in the past, when the limitation period is going to expire, March, September, December, all the chartered accountants are still waiting outside the office of the officer that when the number will come, when he will call us, we can go and explain his case. The better monitoring and expeditious disposal of cases has been inbuilt in the faceless scheme. that before 15 days, a draft order with a show cause has to be given to the taxpayer. No submission would be taken by the system in the last 15 days. This is with the objective to provide a quality assessment orders. So background, if I come to that, the Indian tax system is based on the taxable incomes, purely a self-assessment based system. And the Indian tax department selects only 1% of the returns for scrutiny, not more than that. So what was happening in such a scenario, the penalties are very heavy. If there are certain non-compliance with the tax laws based upon that 1%, to enforce more self-compliant society. Government need taxes. They cannot go and check the 100% tax returns like other countries which are having a less number of taxpayers. So what types of assessment the department can do after the return has been selected? There are certain errors, there are certain parameters. The most important part before introducing this faceless scheme, the government has tried to bring the concept if any mismatch in the data available with the tax department through SFT, through tax audit reports, other forms which have been submitted, various data which they are receiving, and the return forms submitted by the taxpayer. So first they identify it and if any mismatch is there, they issue a defective notice and ask the taxpayers to rectify it. Because in faceless, if every case is being selected, so department has to again manage it. So to reduce the number of cases to be selected for the scrutiny, the first which can be done through this defective concept, we have already seen that once you file the return and there is mismatch from the various sources, a defective notice comes. This information is not telling with the data available with the department. Kindly file a corrective statement. So once that has been done, then the stage comes of the assessment. Every year, based upon the information available, they create certain criteria, certain bases on which basis the cases were selected for the scrutiny. Which type of assessments are there? There are 4 types of assessment in the tax laws. Number 1 is the summary assessment. Once the return is processed, arithmetical accuracy has been checked out, no detail, no information is being called from the taxpayers. It is called summary assessment, more probably known as the 143(1) intimation. Then it comes to the scrutiny assessment under section 143(3). Here the detailed information is being done, asked from the taxpayers, subject condition that in which category the case is being selected, whether it's a limited or a complete scrutiny, which is based upon the parameters decided by the tax department. So if it is a complete, then the authorities, the audit unit, the assessment unit can call whatever information they needed, where they have a suspicion or doubt, or where they need certain clarification, they need a verification of the information before granting an exemption, deduction, or allowance to the taxpayer. The another case is a limited scrutiny. In a limited scrutiny case, the hands of the tax department are being tied up. They cannot go beyond the issue for which the case has been selected for the scrutiny. If while verifying the information submitted by the taxpayer during the course of limited scrutiny, the tax officer decided that he wants a detailed scrutiny, there's something more there, then he has to take the approval from the seniors to convert the case from the limited to complete scrutiny case. Here we need to take care. If he is converting that, then on account of natural justice, he is required to provide an opportunity to the taxpayer that he wants to convert. Then we should retract it, provide our submissions and basis that why he is doing wrong, why the detailed scrutiny is not required. While now where we are moving is a complete faceless era. Being a professional, what we have to check? if any notice or order comes to us, or show cause comes to us, then it is the responsibility of the tax authority to give the rational or justification or reason or satisfaction for that. If the show cause notice or an order is silent on that, that does not pass the test of natural justice, which is my fundamental right, no decision can be taken without any rationale. So, being a professional, we should carry out a critical scrutiny of whatever we are receiving. Whether that notice within time limit, first of all the approval, if required to issue that notice, has been in place. It is my right, being a taxpayer's right, to obtain such approvals, the proof of such approvals from the tax authorities. The another type of case comes is the best judgment assessments, where the assessee taxpayer does not respond to the notices. Then the tax officer resort to the best judgment assessment, where the assessee is not cooperating, he can move to the best judgment assessment under section 144. Here the responsibility on the tax authority is much higher. They have to provide a complete basis and rationale for the decision taken based upon the information obtained, the source of the information, relevance of the information, and he has to apply his mind, and that application of mind should be reflected in the order passed, that information which he has relied upon is completely in an unbiased mind, not from the taxpayer perspective only, tax authorities perspective only. His objective is not to collect the tax. His objective is to get a complete justifiable rationale from the information. And if any addition is required to be made in the taxable income, then the same has to be made. But before taking the result of best judgment assessment, the order of the taxpayer must record the reason that why the assessment has been, the jurisdiction for making the assessment under section 144, a best judgment assessment, has been resorted to. So if the order of the tax authorities are not passing these tests, then the order are against the natural justice, which is help us, all the professionals, to represent the matter in appeal. The third type of assessment is more popularly known as the reassessments. We all know that tax authorities can reopen the case up to 7 years. Here, I would like to highlight that the Finance Act 2021 has changed the provisions of section 147. Earlier, there period that up to 6 years the case can be opened, 6 previous years, 4 years and 6 years, which is just a bifurcation point for taking the approval internally by the department. Now, in the new provision, the period has been reduced from 6 to 3 years. Escaped is less than 50 lakh rupees. But if the tax authority is having a reason with them where the matter is an escapement of income of more than 50 lakh rupees, in such a situation, the tax authorities can open the case up to 10 years. If they have a reason where the escapement is relating to the foreign assets or foreign incomes, then the tax authorities can reopen the case up to 16 years. So before assuming the jurisdiction under section 147, the authority has to record the reason and satisfaction for reopening of the case. The another change which has been brought in by the Finance Act 2017, a major change. Generally, we contest that the information obtained is not from the valid sources, does not pertain to the taxpayer, and the information does not give enough satisfaction as recorded in the satisfaction reason to believe that the income has escaped. In the past also, what we have seen is before the period of reopening, we received the notices under section 133(1), 133(36). Kindly provide the information relating to this. Kindly provide the information relating to this. Our standard reply is that you don't have any pending case, so this is a roving inquiry. You cannot do that. Tax authorities does not have a valid source of information. Sometimes information comes from the investigation departments. Sometimes information comes from other government authorities. Sometimes there are AIR information. Sometimes information comes based upon the audit objections. So while recording the reason to believe, how the tax authority who is recording the satisfaction has applied his mind becomes the reason to believe. If there is a default in that process, that the same has not properly been recorded, in such circumstances, the reason recorded are being quashed by the appellate authorities, and the assessment order passed in 147 went away. So in Finance Act 2021, there is another change has been brought. That is 147B. Now under section 147B, if there is any information and the tax authority needs any further clarification, they may send a notice to the taxpayer asking for the information, giving him an intention of the tax authority that they want to reopen the case based upon this information. You want to say anything? Our contention is right or wrong. This is a show cause to you. Based upon the reply, the reason recorded to be done. The another thing which has been brought, that audit objections, AIR information received from the investigation would constitute a valid information for forming the reason to believe for opening of the case. So this is for the help of all the professionals. So we should take care of it that now from the Finance Act 2021, the law has changed. So while we are doing, starting point is whether the notice issued for selecting the case is a valid, completely valid notice or not. A jurisdiction which has been assumed is correctly or not. We should test them before providing any submissions or proceeding further in the matter. With respect to development so far, we all aware that it has started in 2019 by the budget speech on 5th July by the finance minister. Then section 143 3A and 3B has been incorporated in the Income Tax Act. The basic objective is to impart greater efficiency, transparency, accountability for eliminating interface between the assessing officer and the assessee. There would be no mood swings. When we go to the authorities, there would be no mood swings. We are not required to face the mood swings of the tax authority. Second one is, objective is optimization of the utilization of the resources. We all know that department has a good assessing officers, but all the officers have a limited knowledge. So here the technology will provide the selection and allocation of the case based upon the artificial intelligence to the correct resource for a correct issue. And the third objective is the dynamic jurisdiction. There would be only pan-India basis, one central cell who would be monitoring all the faceless. While sitting in Delhi, I can take the case of the assessee who is sitting in Bombay. I can draft the submissions. Earlier, if the case is from another city, we used to refer it to the other professionals. So now we are not required to do that. We can do while sitting in our office. The another section 143B, which has been introduced to empower the government to issue any rules, bring any amendment in the tax laws to achieve all the objectives as sought in the faceless. But here the government cannot issue any directions after 31st March 2022. Initially, when this scheme was launched, the authority selected only 8 cities for a pilot project. These are all 8 metros: Ahmedabad, Bombay, Pune, Bangalore, Hyderabad, Chennai, Kolkata, and Delhi. Now, complete pan India, there is no city-based criteria. All the cases will go there except where there is exemption for that. Still, these cases will be handled physically. There is another amendment has been made on 13th of August 2020, whereby the order under section 119 has been issued and all the cases has been transferred to the central cell. Now that central cell has been named as a National E-Assessment Center. By this notification, the name of the scheme has been changed from E-Assessment to a Faceless assessment. The cases which will not be transferred are the cases which are under central charge. We all aware that certain cases after the search and seizure operations have been centralized by the department. There are central circles in everywhere. So the cases which has been assigned to the central circle, they will be come under the central charge and they will not be governed by the faceless scheme. The officer sitting in the central charge will do that in physical hearing, face to face. The another is the cases which has been assigned to the international tax charge. The last, after 13th August 2020, if any order is not conformity with the faceless scheme, will be considered as a non-est and will not be taken effective. So no officer can pass any assessment orders. The National E-Assessment Center, which is termed as a central cell, is going to be the face of the department. All the communication between the taxpayer and the tax department will be communicated here. This center is located in Delhi and headed by the Principal Commissioner of Income Tax. It is similar to which we have already seen the CPEC, Central Processing Center, where we are filing all the returns and only they communicate, CPEC is communicate with us. It's a one-way communication. We don't have a two-way communication. If we we don't have any medium to communicate with them that my return is not processed, you can take my help, what you are not understanding. It's completely one-way communication. So again, a National E-Assessment Center is like a CPC. The other functions which has been assigned to them is to define, specify, finalize the formats of various notices, various communication forms, or other internal communications. The procedure followed between the various units which were controlled by the central cell. All the notices will be sent electronically on the mobile number and registered email IDs. They are also responsible to allocate the cases to the regional e-assessment centers. Below the central cell, there would be regional e-assessment centers. Its function I'm discussing later. And these allocation, again, is not manual. It is completely based upon the automated system using the artificial intelligence. Select the draft orders, review the orders passed by the units, get them reviewed, coordinate the review unit, improve the quality. That is the biggest role has been assigned to the central cell. They are also responsible to manage for providing any kind of opportunity to the assessee. For personal hearing, when they use the personal hearing, it would not be we are going face to face. It would be completely a video conferencing or audio call to explain my issue. And upon completion, it is the responsibility of the central cell, National E-Assessment Center, to transfer all the records to the jurisdiction assessing officer. The role of the jurisdiction officer is still there for recovery, prosecution, passing the rectification orders, and some miscellaneous administrative work. The regional e-assessment center is having a 4 units. One is the assessment unit, review unit, technical unit, verification unit. Each regional unit will be headed by the principal CIT, and they are having the center at 8 cities which are earlier there. The assessment unit role is involved identification of the issues, seeking the information which is required to complete the assessment, analyzing that information, the material, the detail and documents furnished by the assessee or any other person or such other function as may be assigned. Their role is to verify the information, seek the information, not verification. Earlier, when what we have seen is all the assessing officers ask the information, review the information, and verify it from the other parties by sending the 136 notices. Here, the difference is verification function has been taken away from the assessment units. Verification unit based upon the request from the assessment unit, which will be communicated by the region, again National E-Assessment Center. That who would be the verification unit? Again, automatic allocation. Their thing is inquiry, examination of books of accounts, examination of the witnesses, recording of the statements through video conferencing. The first and foremost is everything has to be by using the technology. Technical unit. The biggest lacuna which we have seen is assessing officers not understanding my point. My business is unique. We all aware that business has to be seen from the point of view of the businessman. For claiming any expense reduction, the reason why it is necessary for the business, everything has to be seen from the point of view of the businessman. When we go and explain the facts, the first thing which comes to know, officer is not understanding my point. He does not know how to do the business. There is certain part which is lacking is the knowledge. They have their limited knowledge. Now to provide that knowledge to the assessment unit, assessment unit can ask and obtain all the knowledge from the technical unit. The role of the technical unit is provide advice on the legal issues, accounting issues, forensic, information technology, valuations, transfer pricing, data analytics, and so more. So any kind of technical advice they needed, there is a technical unit now has been developed. So which we seen, which is definitely would be available when the orders will come. Now there would be interaction between the various assessment units. We can see and expect that the standard orders will come for certain issues which has been identified by the tax department. For these issues, these would be the orders. These basic thing has to be in the order, so that to avoid the multi-layer litigation on the same issue, two officers, one sitting in Bangalore, one sitting in Delhi, pass a different order in a different language using the different reasons for that. Two high courts gives a different and conflicting views. Then a matter travels to the Supreme Court. If the order is coming in a standard way, definitely based upon the law, the different high courts would give the same reasoning and pass the same orders. In the long run, this will help. But how internally department will function, we all don't know that. In March 21, the orders which have come, major orders, either they are coming nil, it's good. If there is addition, they are going into the writ. More than 35 writs has been passed. And in the various high courts in India and from March and April. The basic reason is opportunity has not been provided. Notice, show cause notice has not been issued. Draft order has not been issued. There are more than 35 writ petitions has been admitted by the high courts. all orders have been stayed up. You are issuing the notice on Friday, asking me to submit a detail on Monday. And when on Monday I'm requesting for the adjournment, there is no communication, one-way communication, and order has been passed. There has to be a system for automatic date. There has to be communication whether my adjournment request has been accepted or denied. It has not been, there is no communication system. We all seen when the notice come, we go and pass the adjournment. But when the next notice will come, we are not aware of it. Department is working on it. We can expect, because after so many of rates, this matter would have been taken at a higher level also. The review unit, a big function. Earlier, officer who is passing the order, he is himself reviewing it. Sometimes he take the help of his senior additional range heads. Sir, I'm passing this order. Can you help me? I did not made any mistake. But now, based upon the risk criteria, all the orders will be go to the review unit. The basic role of the review unit, whether first and foremost, whether all the relevant information, material evidences has been brought on record. The assessment order forms the basis of appeals. Every authority first of all see the assessment orders. Then they go to the CIT appeal orders. Then the ITAT orders comes, it add-on values. But what is being captured in the assessment order? It is very important. The another thing, whether all the relevant points of facts or law duly incorporated in the draft order. So if any position department is taking on a particular issue and that matter is being contested at a higher court, the apex court, then whether the same has been incorporated or not. All the relevant department favors, case law has been considered or not. Whether the issue on which addition or disallowance has been made, it has been properly captured, all the relevant facts and the law points. All the applicable judicial decision has been considered and dealt. Not considered, it has to be dealt. We all aware there are two concepts. One is the stare decisis, legal maxim. The another is the obiter dicta. For any judgment, the 2 points which need to be bifurcated by any professional, one is the obiter dicta and the stare decisis. Obiter dicta says when any certain decisions, law point or reasoning can be used by the judge for arriving at the conclusion. They are passing remarks. But what has been captured in the conclusion? What has be the basis for decision is called the stare decisis. So now drafting has to be reviewed. The way they have created the structure, we can see a dynamic change, but which need a lots of training among the tax department. Last but not the least, arithmetical correctness or any other function as may be decided. Which type of cases are covered? The person who has furnished the return of income under section 139(1), the return which is within time limit. Under section 142(1), upon the notice received from the tax authority or in response to reopening of the case under section 148(1), or a notice under section 143 is issued for selection of the case. Where the assessee has not furnished the return of income in response to notice under section 142(1), the same would be covered. Where the assessee has not furnished return under section 148(1), the same is also covered. In response to notice, not covered. And where the notice under section 142(1) of the Income Tax Act has been issued by the assessing officer. These are the cases which are prior to introduction of the scheme. Now they stand transfer from 13th of August 2020. So here the tax authority department does not require to issue the 142 notice again. There is a notification has already been issued that all the notices issued under section 142(1), whether they are jurisdiction or non-jurisdiction, are valid notice. Earlier, we used to take stand that notice has to be issued by a jurisdiction officer and the order has to be passed by the jurisdiction officer. But now, because it's a dynamic jurisdiction, no single person can be tied up. So for this purpose, the removal of difficulties, these provisions have already been inbuilt in the scheme. This I have already discussed. What are the major changes from the 13 August 2020? One is the name change. Best judgment assessments are also covered. Earlier they were not. Rules were not mentioned in the earlier scheme, which has been now incorporated, that it means the income tax rules. The process of seeking the adjournments has been made in place. It's till now it's a one-way communication. Being an taxpayer, being a professional, I should be made aware that whether my adjournment request has been accepted or not. Adjournment is not my right. It is a discretion of the officer. Penalty orders are also covered, and another national e-penalty center has been created. Central cells are being empowered to lay down their rules for execution of their work delegated to them. But that is subject to approval from the CBDT. All the notices has to bear a digital signature. No notice is valid without a digital signature. DIN number is must. A detailed procedure has been put in place. And in the new scheme from the August 20, the concept of personal hearing through video conferencing has been inbuilt. This is the broad diagram that first of all assessee, he went to the e-filing website, that is Income Tax India e-filing.gov.in. Then National E-Assessment Center comes into the picture. After that, which has been supported by the Regional E-Assessment Center with 4 units. This is hierarchy. If I would like to brief the initiation process, first, based upon the parameters, based upon the guidelines, based upon the directions, drafted on the risk based in the past, in data available, information available, the case is selected. Then National E-Assessment Center allot the case numbers and allot the same to a assessment unit through regional assessment unit. Then assessment unit study it based upon the information available, income tax return, balance sheets, financial statements, tax audit reports, or other available information in the department through SFT or any investigation submissions. They prepare and draft the first questionnaire, which is along with the notice under section 142 has been issued to the taxpayer. This notice drafted is being submitted by the assessment unit to the National E-Assessment Unit, which issues that notice to the taxpayer. Assessment units cannot interact directly. They have to inform to the National Center, which will be in turn issued. The process starts here, and all the required information, details, evidences need to be submitted at the portal. There would be no email interaction between the taxpayer and the authority. All the submissions has to be go to the e-assessment portal. It is being, again, just to highlight for the persons, that Income Tax India e-filing.gov.in after login provides the e-proceedings tab, where all the proceedings which are open in case of a taxpayer are mentioned there. Closed proceedings are also there. All the records of the proceedings is there. Taxpayer can go and download it, which is a replica of my submission made by me, and the notice is issued by the tax authorities, date-wise, chronological order. how it is being done, the complete process is nationally assessment notice will issue the notice under section 142 or 147. Assessee is required to submit the response within the time frame given. Then National Assessment Center will assign the case randomly based upon their automatic allocation system to the assessment unit to any region. It is not required that Delhi case will go to Delhi. It may go to Bangalore. It may go to Ahmedabad, where the assessment unit is situated. Assessment unit will obtain the information, whatever is required additionally, through national unit. Assessment unit may take the help of the verification unit for verification of the various information, various details submitted by the authority, by the taxpayer. Assessment unit can also take the technical assistance from the technical unit for taking the various technical inputs, but not directly. Earlier, we have the access to the files, order sheets, which we undertake, which we obtain under RTI from the tax authorities, because being a taxpayer, it is my right that what has been done in my file. But what communication is going between verification unit, technical assistant units is not available to me. How it will be made available to me, which forms the basis of the decision, we will see in future. But here one thing is very important. If based upon the inputs on the verification unit or technical unit, any adverse inference is drawn to me, it has to be confronted to the taxpayer. All the relevant evidences and material need to be confronted to the taxpayer. Earlier also, when the officer obtains certain information, the officers issues the notice along with the information obtained from the third parties. How the same will apply to the income tax proceedings, there are two opinions. One, whether the verification unit is required to confront only the adverse details or information, or all the information which has been obtained, favorable to the taxpayer also. So in a legal jurisprudence, it is being held in various cases. All the information obtained by any authority which forms the basis of relying, whether favorable or not favorable, thus all complete information has to be disclosed and shared for opinion. As of now, this process is not transparent. So we will see in the future, but we have to be very careful and control it if any notice comes. So what is the reason behind the issuance of the notice? Whether the notice gives the enough opportunity, enough detail for confronting the material there. The same has to be provided to taxpayer. If it has not been done, then we should take care of it and ask the information before giving our reply. It is my taxpayer right as a taxpayer. Once verification unit does, technical gives, assessment unit, based upon all the available inputs, they prepare a draft order. Now that draft order, if it is not prejudicial to the assessee, not prejudicial, then finalize the order and send to the assessee. Transfer all the records to the assessing officer. What if it is prejudicial? If it is prejudicial, it will go to the review unit. Review unit will give its input. Based upon all those inputs, again, any suggestion is there, it will again go to the assessment unit, incorporated, and a review will be done. Once it will there that there's no more suggestions, then it will be given to the assessee for providing an opportunity for the draft order. Without giving a draft order, a final order cannot be passed. Draft order along with the show cause notice, it is must in the new scheme to be provided. Earlier, officer says, okay, you have submitted all the information, I will see to it and pass the order. Order comes to us as a surprise. Then we find the lacunas all inbuilt in that and go to the appeal, where we submit the additional evidences, additional information, additional grounds to avoid the multiplicity of litigation. the draft order is now being provided to the taxpayer. The scheme clearly says and mentions that any order without providing the opportunity of the draft order is not a valid, because it is not in consonance with the scheme as prescribed. Draft order has not been provided in the writ petition. The effect of the order by Bombay High Court has been stayed. Now department is required to give its submissions and reasons. The future will be there. How it will come, whether the department will get another opportunity or not. But according to me, once the authorities have a sufficient time and the procedure is defined, and if it has not been according to the such procedure, there is a closure. The same way it's applicable to me. If and I am required to submit any information, then at higher level, if I'm going for the additional information and submission by way of additional evidences, then it is at a discretion. If there is no sufficient reason, they can reject my request. So why the officer is getting another time? By this, once draft order, if any objection will come, they will be again dealt with. Review unit will come into the picture, that again what is required to be captured in the order. One thing, being a professional, we have to very remember, whatever we will say here, we need to consider that what new we are going to say in appeal, whether there would be any additional ground or not. So that draft order definitely will come at the completely fag end, giving us a lesser time. So we should be prepared with that. We should, my suggestion being a professional is that reply to the draft order must be submitted. Must be submitted. Otherwise, all the grounds which I'm going to take will become an additional grounds for me at the appellate stage. A complete and proper reply. If any information has been missed, the same has to be brought on record. Definitely there will be lesser time. Now pandemic is going on, information, how to collect the information and collect is a challenge. Once the order is being passed, all the record will be go to the assessing officer. Now, if in the assessment order there would be any rectification, that will be dealt by the jurisdiction officer based upon the record comes from the assessment unit. They are responsible for the recovery of the demand. They are responsible for providing the appeal effect of the order. They are responsible for providing the remand reports to the Commissioner of Appeals or appellate authorities if any requested. They are responsible for representation before appellate authorities, filing the appeal at higher forums, ITAT, High Courts, Supreme Court. Last is the launch prosecution. In the past, we have seen now department is more active for the prosecution. We have to be very careful. Earlier, the assessing officer, tax officers are having a lesser time due to the assessment burden that has been taken away from them. Their task is very limited. They have enough time to prosecute, to prepare the complete file, to prepare the case. So we need to take care of that. All the communication between the taxpayer and tax authorities is only through the portal. Every document should carry a DIN number, document identification number. Any notice which is without document identification number is not a valid notice. Any communication has to be tested on all the points that I have already discussed in very much detail. This process I've already covered. So I'm moving forward. This is very important. Earlier is being added by the physical appearances before the tax authorities. Now all our submissions are written submissions. People says now everything has to be written. In my suggestion, in my view, that writers are not born, they are not made. Not true. They are made. We made ourselves writers. The best thing which I have learned from my experience, which I would like to share with all of you, if I am able to make the changes in my written document, then I am improving. Perfection needs improvement. If we will review our own submissions and improve it, make it, edit it, and make it to the point, then we are a good writers. The basic thing while editing is, generally we follow and we suggest that we should prepare the submission at least a week in advance, so that giving a 2 days gap, we can again go and read the submissions which we have made. That is on the single parameter, whether the submissions, the write-up which has been done is making a sense the way it should be. Simple test. Forgot everything. Coming to the point that we need the technological guys in the office. What is the difference is there that what the seniors have and what we are not? We start writing on the computer, edit it, and review it on the same moment. Leave it for 2 days, so that when you review it, it's fresh. You are able to identify your own mistakes. Seniors, what they do, they give the dictation, the steno goes outside, he type it, next day he comes again with the submissions. They review it. This is the key. Either you give the dictations, if you are doing yourself, then give enough time in between of review and first draft. We will see the change and difference. In the written submissions, there is lots of emphasis. First of all the facts which required for a decision making has to be captured. Facts on which we are relying, we are additionally filing the other documents. They has to be completely paginated. Cross-reference should be there. Earlier, when we go over the assessment, we take our file, sir, this page number, you just see this paragraph. If I'm referring a particular page number on a particular paragraph, then my submission on that particular submission area should highlight at where the assessing officer has to go. I'm required to file the complete 100-page balance sheet, financial statements, along with the audit report, notes to accounts. I may be filing the confirmation from various parties. There are other things which I'm filing, various contracts. So which paragraph, which point I am referring to, it should be so cross-referenced that it is easier for the person who is doing the job. We have to assume that he does not have a time. He is going through the multiple pages. So that is all the facts and should be mentioned properly and cross-referenced. Use of PAN number. Sometimes people take the printouts. Whatever submissions we are giving, it has to be page numbered. PAN number, name of the assessee, and the proceedings for which year has to be mentioned. Respond within time. Respond within time. Client has to be teach. Don't come at the last end. Please provide the question for review. Once anything is uploaded, we should move with the positive approach while drafting our submissions. Any specific questions we should negate. But if the questionnaire is looking out certain answers to the certain questions, my submission should cover them. They should be visible. After mentioning the factual positions, if we are relying on any legal submissions, then 100% that legal submission has to be given. Again, before relying on any submissions, don't trust on Google. We should obtain the true copy of the judgment and read it. What are the facts? Whether that judgment fully fits into my case or not. If there's a slightly difference of the facts, it changes the legal position. Don't trust on Google. There are various terms which are being used. Assessment, as mentioned under section 143 of the Act. E-assessment, e-proceeding facilities, assessee's registered account. Assessment is a replica of e-assessment at the portal. Assessee's registered account at income tax portal. Now that return filing time is coming up, we should re-verify the information submitted at the portals for all the clients, that what are their registered email addresses being mentioned and the mobile number. Mobile number is strictly the number which is working, so that if any notice being uploaded there, it comes to the SMS also, that go and check the notice at the site. So we should notice come to us as a professional in a timely manner. Assessee would be having a timely information on the notice, so that he can provide all the required information well in time. Registered email importance is completely very important. We should again cross-check all the database. The challenges, I keep discussing the challenges available with the department is they need a robust and secure data system.
Rajeev ji, how much time will it take to complete the deliberation?
Sir, appeal I will take 15 minutes.
No problem. And we are having 4 or 5 slots on Zoom platform. So
Okay.
those who are not with us can join. We can communicate to them, or the members who are on YouTube can also join on the Zoom. Yeah, thank you.
The another thing which which will definitely help us, if the bandwidth has been managed. At income tax time, the sites does not work. Here the bulk document has to be filed. While the another thing, capability of handling the bulk submissions, how they will be at the back end. Adequate training, which is very must. Sir, first and foremost challenge for us, updation of the email IDs. Many times we have seen the notices are not being come to the knowledge of the taxpayers. Digitization of the data. This pandemic has explained so many things to us, that we need a digitization of our offices. A server system, all the data has to be scanned, indexed and archived, so that it is easily available. But while preparing the submissions, it has to be digitized, scanned, digitization done, numbering, indexing. This is a critical task. So before starting the submission, we should identify that on which document we are relying. We should create the index, so that while preparing our submissions, we are having a complete cross-reference. Fake communication, we can verify the DIN numbers. We can download all the notices from only registered portal only. Do not rely on the notices received in the mail. And basic structure, which we have already discussed, it will help us to understand that how we need to respond to a particular information, how it will be taken up and how it will be processed. What is with FACE? As of now with the department is rectification with the jurisdiction assessing officer, a revision prejudicial to the department under section 263, favorable for the assessee 264 of the Income Tax Act with the commissioners, recovery of taxes and demands raised, stay of demand, administration, prosecution, compounding of offences, and if we require to file the closure of the business proceedings. It is still with the FACE. Benefits, the major benefit is the saving of the time going to the tax offices. We are going for one case, it takes half of our day in Delhi. Now, while sitting in the office, we can provide a submission as per our convenience before the last date. All the records would be made available at the appellate stage. No file is required to be maintained. We can go download it from there whenever is it needed. Now coming to the new scheme of the faceless appeals. Before I will start with the faceless appeals, it is on the again same parameters on which the faceless assessment has been done. Same objective, eliminating the interface, optimizing utilization of resources, and a dynamic jurisdiction. I will discuss the major changes, what is there in the from the faceless to assessment to there. There are only three layer. One is the National Faceless Appeal Center, then the Regional Faceless Appeal Center, and appeal units. Same appeal unit will function as a review unit also. Same commissioner appeal would be reviewing the draft order passed by the different appeals. Before moving to the next topic, just giving a reminder, when we file the appeal in any matter, we should take care any penalty notices issued with the assessment orders. We should file the proper reply. As per the scheme of the tax laws, all the penalty notices issued with the appeal can be kept in abeyance till the time the matter has been decided by the appellate authority, that is Commissioner of Income Tax Appeals. So we have two options. Either we can give our submissions on merit in the penalty proceedings, or we can request for the keeping the same in the abeyance till the appeal is decided. Another thing, if any additions are being made and demand has been raised, there were no losses which has been adjusted, disallowed. So there were demands made on the addition or adjustment made in the assessment orders. We should compulsorily file, either deposit or file a stay or demand application. Once 30 days time period has been lapsed, then assessee would be treated as assessee in default. 221 interest is also there if the stay application is not there. Again, make sure that all the penalty notices are replied, taken care of, and stay of demand proceedings. Department can up to grant the stay after depositing 20%, but in other cases they have the discretion. That is discretionary power. But if appeal is there, then we should ensure it. Now coming to the faceless appeals, there are only three part: National Faceless Center, which is act as a communication channel; regional faceless centers act between the national center and the appeal units, and appeal unit. No verification unit, no technical units, only no review unit, separate review unit. They will become the review unit for any other draft orders. The role of the appeal unit: admitting additional grounds of appeal. If anything not raised for the authority, any grounds, they become the additional grounds. So this is at the discretion and relevance to the case. In National Thermal Power, George Tools Limited, CIT was a Singhar Technical Society, court has held that then the same has to be admitted. It has to be drafted. It's simple art. If we spend time, we can learn that. Appeal to be done. Then the verification unit will come and they will make the required inquiries. Any other information which is required for admitting the additional grounds. Providing the opportunity to the appellant. Review of the draft order passed by the other units. Admission of appeal. Appeal is a statutory right, which is granted by the substantive right to me by the tax provisions. This is not my fundamental right. This is a statutory right. So authority can admit the appeal only if the appeal is as per the provision of the law. The first thing which is required to be done is whether the appeal is within time or not. The appeal to the CIT appeal has to be filed within 30 days. If there is a delay, then delay has to be justified. There is a clear-cut judicial pronouncements. Tax law also incorporate this, that notice served on the email ID is a valid service of the notice. The intimation coming to the registered email ID that order has been passed on this date, you can go and download it. It's a valid communication of the passing of the order. So if there is a delay beyond that, has to be reasonably justified. So first and foremost is whether there is a delay or not. In the case of the perfect scale, it has been held that delay in filing of the appeal on the advice of the professional is condonable. Delay attributable due to the action of the professional is a condonable delay. Or any other reasons need to be justified based upon the cases, case to case, based upon the facts. The another thing is, there is one question is being asked while filing the appeal in Form 35, whether if the return of income is filed, whether the tax has been paid on it or not. A return without payment of the tax is not a valid. It can be rejected at the admission stage only. But it is again discretionary. If the reasons are there, based upon the reason, the appeal unit may decide. Based upon the various information received, appeal submissions, the appeal unit will pass an order. That draft order will be submitted to the National Appeal Center. Based upon the internal risk criteria, that order will be decided whether it has to be reviewed by the review unit or not. If the appeal order goes to the review unit, then the review unit gives any suggestions for incorporating in the draft order, then the suggestions and the draft order will go to the another review unit. It will not come back. Once a person has taken, appeal unit has taken a decision, it will move forward. Once there is a concurrence of view, then the draft order will be communicated as a final order to the taxpayer, appellant. The draft order will not be communicated to the appellant at all. Likewise, in the assessment stage. This is the another change. Additional evidences, if the additional evidences as required to be submitted, an application requesting for the admission of the additional evidences must be submitted, citing the reasons for not submitting earlier. Then the appeal unit may decide that whether to admit the additional evidences or not. If it is being admitted, then they will be required to be given to the assessing appeal assessment unit for submitting the remand report. What they have to say on the additional evidences, the opportunity has to be provided. That remand report will also be required to be communicated to the appellant to give his objections. After that, the order will be passed. If during the course of appeal, if any enhancement or imposition of a new penalty, then the notice will be issued by the National E-Assessment Center. That communication has to be passed on. Opportunity of personal hearing is there. That is again a complete discretion of the authority based upon the request, complexity of the case, complexity of the facts of the appellant. Based upon that, the opportunity will be given or not given would be there. It is a serious breach of the legal maxim audi altum pattern that opportunity of being heard to the opposite party has to be given. Only based upon the written submissions, it has to be decided, but in which is again the decided laws. So how it will be taken up in the future, the time will tell to all of us. Now may I ask for the questions. Anuj, please take the questions.
Please stop screen sharing, Rajeev ji. So
Done,
thank
sir.
you very much, CA Rajeev Ahuja ji, for very nice deliberation. I think we are having a house full. 500 delegates are there on Zoom platform and others are there on YouTube still. So Rajeev Bhatnagar ji, my very good friend from Ghaziabad, the assessee have not paid service and the IT department have added back to the income and raised the demand and adjust the demands from the next year's refunds. Still, the assessee have not service tax, as the service tax was not debited in the P&L. Then now what is the solution?
So if there is a section 43B clearly says that service tax, if any collected, has to be deposited. Or if we are following the Mercantile system of accounting, if for claiming the exemption, that has to be deposited.
Yeah.
Department well within the right to make such adjustments.
Right. Thank you. Then CA Sushil Kumar Sharma ji, how to file a rectification under section 154 when order has been passed and window is closed?
As per the scheme, once the assessment is completed, all the record is being transferred to the jurisdiction officer. The rectification application can be filed before the jurisdiction officer.
Right. Then my good friend CA Nishant Matin ji, whether there is any specific format of matters to be included in assessment order, whether there is any reason for not mentioning name of AR in the assessment of or appellate orders passed under Faceless scheme.
So whether it is the question whether the professional has filed his authority letter, power of attorney, wakalatnama on the online portal or not, on which behalf the submissions are being made. If I am just signing the submissions and my authority letter is not being submitted, if we see the proceeding tabs, there is an additional column that whether any AR has been appointed or not. So if that is there, then they are required to maintain who has submitted the details. Otherwise, who has submitted details, why they have not passed the best judgment assessment, it is again a challenge.
Yeah,
But
thank you.
the professional, we should mention the submit of authority letter.
Yes. Then Kavita Garg ji, sir, ITR of assessment year 1920 has been filed on 31st July. But sir, some income by mistake not taken in that ITA return. ITR revised date also over. What will be remedy? Kindly suggest.
Kavita ji, in your case, that as the time has already been elapsed, and at the start of my presentation, we have already said that the Indian tax law is based upon the self-assessment basis. So it has been considered and expected that the complete and correct return has to be filed. So now if the matter will come, they will come from the department side, would be considered as a concealment of income based upon the facts of the case. So there's nothing can be done.
Yeah. Then Preeti Tyagi ji, summary assessment under section 143(1) for all ITR will be done by CPC or NEAU?
CPC.
Yeah. Right. Then C. Ankur Agrawal ji, what if final order is made before the due date of reply on draft order?
So again, the draft order has not been given to me. Opportunity has not been granted. The time allowed to me, give me to provide the submissions. It is not based upon the scheme. It can be challenged.
Right.
And in the Bombay, in SK Lakhotia, this is the only issue.
Yes. Then CA Ashish Kumar Baheti ji, source of getting certified copy of order on which I relied for submission of our reply.
You have downloaded the order, it will carry the digital signatures. So it is a valid, no, nothing is required to be certified. You can take it on your own certified copy and submit anywhere.
Yeah. So then C. Arvind Singh ji, my very good friend from Bareilly, adjournment, you pointed out that it's now not a right of assessee. And what are those kind of situation? It's become inevitable and reasonable opportunity must be given. Reasonability, what does it refer in this case?
When I will submit my adjournment application, then it should be reasoned. If there is a cognate reason to grant the adjournment in the interest of justice, then discussion has to be exercised accordingly. So it can be challenged.
Yeah. Then we are having certain participants who want to ask the query. Arvind Janji, you can ask your query. Rajesh Voraji, you can unmute and ask your query. our very senior members, Dr. Satrughan Prasad Agrawal ji is there. Satrughan sir, you can ask your query. You can unmute and ask your query. Gautam Suklecha ji, you can unmute and ask your query. And Jitendra Kumar Agrawal ji is there. You can unmute and ask your query. Jitendra Agrawal ji.
Anuj,
Yeah. Hello.
Jitendra
Yeah,
Agrawal
good
ji
evening,
from
sir.
Lucknow is there.
या गुड इवनिंग सर. सर मेरी एक क्यूरी है कि मेरा फेसलेस में असेसमेंट ऑर्डर इशू हो गया, देन मैंने टैक्स का पेमेंट कर दिया और उसके बाद में इम्यूनिटी की एप्लीकेशन लगाना चाहा आईटीओ के पास में, तो आईटीओ ने डिनाई कर दिया, वी डोंट हैव एनी डॉक्यूमेंट.
so that is their problem. They are not relying seeking the details from their portal. If they don't have, they can seek it internally. This is not the answer which they are giving.
Sir, they did not accept my application of immunity. Then what will I do?
So you just mail it to the concerned person on the mail ID available with you, and they have to respond.
Sir, I have sent the same, but no order issued by the officer within 6 months. Then what will remedy?
So it has to be assumed. If any something will come, then it is against a violation of natural justice. So based upon the reasons and all these facts of the case, the next course of action can be decided.
Okay, sir. Thank you.
Ayush Bankaji, please unmute and ask your query. Ayush Bankaji.
Geez, thank you, sir. Sir, I need to ask that in this pandemic, whether there is any further time extension in filing of first appeal beyond 30 days?
So Supreme Court has extended all the time limits by first in 20 and now on 23rd March of 2021. So
Okay.
till the time that order is there, the date has been extended, and there is a circular number 10 which is issued 3 days back, which clearly take the cognizance of that order issued by the Supreme Court, and now they have also extended the appeal filing date.
Okay, sir. Thank you, sir.
Yes. Arvind Jain ji, Satrughan Prasad Agrawal ji, if Aditya Ghia ji, if you are having any query, you can ask. Gautam Suklecha ji, if you are having any query, you can very well ask the query. Yeah. Then Rajiv ji, Aditya Ghia ji is having from 35 for Form 35 for appeal has been filed 1.5 years back, and there is no communication from the department either on mail or on a proceeding tab.
Sir, here I have filed 2 years back. There is still no communication is coming on any of my appeal.
Mhm.
So we can wait when they will start. They
Yeah.
are working on Vivad Se Vishwas. Now they will take up and how they will allocate the cases.
Yeah.
So depending then we can expect the notice anytime.
Right. Then Pawan Diwani ji, whether extending dates under section 148, 147 using taxation and other laws, relaxation of certain provisions, ordinance 2020 is valid in law as per your opinion, as this is not beneficial to the assessee.
So beneficial to the assessee. It is not necessary that all the orders should be issued, which is
Sir, your voice is breaking. Sir, your voice is breaking. Rajeev ji, your voice is breaking.
earlier also there
No, earlier it was okay, but now your voice is breaking.
just a second, I'm just checking it. I hope that now it is fine.
Yeah.
Okay. So it is not required that all the beneficial authority can issue the earlier also for the assessment dates has been enhanced. Filing of tax audit detail, it is beneficial to the assessee, but prejudicial to the department also. So if one-sided order is there, it can be also there. But
Yeah.
the one thing is there, it is expected that it will not extend it beyond 31st of May.
Yes. Then CA Amit Sarda ji, in summary assessment under section 143(1), benefit of carry forward loss is not given and liability of tax has been created by department. What is the remedy?
So first of all, please check whether I have disclosed all the required information in my income tax return.
Mhm.
If I have given the correct date of filing of the return of income for carry forward of the losses, and also the amount calculated correctly based upon the earlier returns. if everything is right, I can file the rectification request. That is the remedy.
Yeah.
But
Sir,
they are going to compare only with the income tax return.
Yeah. Right. Then CA Vaibhav Goyal ji, AU passes assessment order and no draft assessment order is received. In computation sheets, loss is reduced by AU and order is cryptic, merely mentioning that assessment as per a computation sheet. Should we go for rectification under section 154 as no question reducing the loss was asked or appeal?
Sir, this is, you have two options. This, if the order is not speaking and draft order has not been given, considering the quantum, you can decide whether you want to go in appeal. Appeal must be filed along with rectification request. And also if the quantum is very much high and the demand would be there, then resort to the writ jurisdiction of the High Court can be taken up. Because in 1 or 2 or 3 cases it has been done.
Yeah. Then Vaibhav Goyal ji again, whether Form 68 immunity under section 270 AA is required to file with the JAO or merely uploading on e-proceeding module under penalty link is enough?
So there is no such clarity being issued. But as per the scheme now, all the penalty has to be taken by the National Penalty Center. So that immunity, if against that notice, if I submitted my submission that for the immunity, it has to be taken care of. But within period of 30 days and no appeal has to be filed.
Yeah, thank you. Then lot number of members are asking, requesting for the PPT. If you can share the PPT, nothing like that. And if you can attach it on the chat box, I don't know if it is possible, you can do it. Aanchal Bhargav ji is also.
I will share with the convener and they can email it.
Yeah. And Vaibhav Goyal ji, if AU considering decisions of non-jurisdictional order passes order ignoring the jurisdictional High Court decision cited by assessee in response to SCN, should we go for rectification?
Sir, here, because two views are possible, apparently he has not considered the jurisdictional orders, complete breach of the binding precedents of the orders. But it will not help under section 154. Practically, the appeal would be allowed.
Yeah. Then we are having one query from.
So there is one query which I would like to take. Anand Mohan ji.
Yes, yes.
Some of the mail of the assessee was my mail. Now the mail comes from the department on my mail. What is my responsibility? Sir, in case of the NRA, it has been clearly been mentioned that a authorized representative or a professional, if any communication is done, it's a valid service.
Yeah.
So either when a client left, let the mail ID change. Now it is a responsibility, kindly inform all the persons so that you have done your part. Now if he is not taking action against the notices, it is his responsibility.
Yeah. Yes, yes. Then Ankur Agrawal ji, what if final order is passed before end of due date of submission of reply of draft assessment order? Already answered, na?
Again, yes, already answered.
Sushil Sharma ji, how to communicate with jurisdictional AO, whether we can file physically also?
With all the income tax department, there is an ask center. So whatever submission you want to give, you can go and submit there. It will reach to the jurisdictional officer.
CA Piyush Lalit Chodia ji, in one of the case, our appeal has been allowed by the CIT appeal for the assessment year 16-17. For the assessment year 17-18, the appeal is now pending with the National Faceless Appeal Center, NFASC. The matter for the assessment year 17-18 is identical to assessment year 16-17. We have submitted the written submission to NFAC along with the order of the CIT appeal. What will be the opinion of NFAC in such cases?
Again, not faceless. So it will be handled in the same manner. Earlier order are binding on the persons to the person who is again coming to the next years, which is it is a applicable law. So they will follow the same.
Right. Then Mohammad Imran ji is asking, sir, ITAT appeal is covered in faceless appeal or not?
Sir, in 2021, while presenting the budget, Finance Minister has shown his intention and certain provision has been introduced, but they have not been given effect till now.
Yeah. Sanjeev Sinha ji, department sent notice on mail mentioned in ITR of the relevant year, not on the profile mail ID. Is the notice is valid?
Yes, because I have submitted the email ID to the department. When we go to the mail ID, it is registered mail ID submitted on the ITR, submitted available at the MCA site. They all email IDs are valid email IDs.
CA Prerna Periwal ji, one of my client earned income from Dream 11. TDS deducted under section 194B, which cannot be claimed, was credited in his account along with other refund. On verification, it was found that return was wrongly filed, so I revised the return. But now, what we should do about the refund received on gaming income?
So practically, we have no such issue comes to us. But if I have the law says that if I have included any income in my income tax return, and then if there is a deduction of tax, the credit or the taxes has to be granted.
Yeah. Ankur Agrawal ji, sir, we filed application for rectification of final order, but no action taken. What to do now? Shall we file appeal now?
If the two views are possible, there is no arithmetical accuracy or something which is on the face of it, there is a chances that 154 may be rejected. We should file the appeal within the time allowed.
Yeah. Some of the members want to ask the query. Rajesh Vora ji, you want to ask any query? Dr. Satudhan Agrawal ji, any query from your side? Yeah, Aditya Ghia ji, can adjournment be given beyond 15 days time for 143(2) under Faceless?
It is depend on the reason cited. If I'm saying that I've been down with some critical illness and there's a time limit to pass the order, they have the authority to give.
Yeah. Then Preeti Tyagi ji,
It's completely a natural justice and discretion.
Yeah. Then Preeti Tyagi ji, if ITR of assessment year 2021 has become invalid due to late e-verification, should we file condonation or file a fresh ITR? Because if condonation is denied after 31st May, we will not be able to claim refund after 31st May.
It is advisable that return should be filed before 31st of May.
Thank you. Shashank Goyal ji, appeals filed 1.5 years back already answered?
Yeah, already answered.
Manoj Saini ji, what remedy is available if we missed the last date of first reply of hearing with CIT appeal?
Generally, it's a practically another notice is come.
Yeah. Then CA Anand Harnathka, order passed by CIT appeal Faceless without considering assessee online submission. Remedy with assessee as the quantum is less than 25,000.
So it is again practical decision whether you want to file an appeal to the ITAT or not.
Yeah. In the Prakashi, I'm filing my client's refund return on 9th January 21. ITR status is process, but not a refund given till date, and what process for receiving refund?
So you may issue the grievance at the income tax portal.
Yeah, then Atul Agrawal, whether AO call upon the partner's personal balance sheet and bank accounts during scrutiny of partnership firm. What consequences if firm not submitted the partner's personal balance sheet, etc.?
It depends at what is the reason for selection of the case. If there is a capital introduction, then he may ask to verify the creditworthiness of the partner bringing the capital in the partnership firm. It's purely depend upon the facts of the case, whether it really required or not. Then he can,
Yes,
based upon that, he can take the complete opinion. Decision.
Yeah. Right. In e-assessment order, addition made on account of late deposit of ESI and PF, can I file appeal against this order or not?
Sir, if it is an employee contribution, we can check the amendment made by the Finance Act 2021, which is clarificatory in nature and made retrospective effective. So no benefit would be achieved in the appeal.
Right. Then Ankur Agrawal, what to do when assessee is died and filing of appeal is pending in Faceless assessment order?
Their legal hearers can be added in the income tax portal, and then the legal hearer can proceed with the appeal.
Yeah. Then Arun Kumar Mathur ji is appreciating the deliberation of Ahuja ji. Vinay Goenka, sir, PF and ESI has been deposited late just for 1 day of the statutory due date. All such expenses has been disallowed. Can we file appeal for this?
Again repeated in question. Please refer the amendment as being made in the Finance Act 2021.
Yeah. So lot number of other queries are there. Lot number of members are appreciating Preeti Tyagi and other Vaibhav Goyalji, whether order passed in 1 year by NEAC, NFAC would have any binding precedent in faceless regime or on another case on same issue, being coordinate orders.
Sir, res judicata and binding precedents from one assessee to another assessee does not work till the time it is passed by any higher authorities.
Yeah.
But it's a group of cases. If family is there, then that stand can be help us to elaborate it. If there is a joint owner in the property, and for the treatment of the return in one person is being done, the same has to be followed in another case, which is already being held by the Calcutta High Court.
Yeah, my good friend Manoj Agrawalji from Prayagraj, Allahabad, is also appreciating the deliberation of Rajeev ji and efforts of Jawahar Park CP Study Circle.
Thank you, sir.
Then Arvind Singh ji, don't you agree after assessment relevance to CIT appeals and 154 cases to be in favor of assessee is relevance got diminished?
Sir, can you repeat the question, please?
Don't you agree after assessment relevance of to CIT appeals and 154 cases to be in favor of assessee is relevance got diminished? Not very clear.
Yeah.
Yeah. So I think we have to close at the earliest. Some of the participants want to ask the query. Hima Goyal ji, please ask your query. Hima ji, you want to ask your query? Or Aditya Ghia ji, Ayush Banka ji, Gautam ji.
Sir, Oja ji bhi has also raised his hand.
सर छोटी सी एक क्वेरी है. सुप्रीम कोर्ट ने एक जनरल ऑर्डर निकाल दिया कि जो भी ड्यू डेट है ड्यूरिंग दिस पेंडेमिक सभी को एक्सटेंडेड माना जाएगा.
जी सर.
अभी हमारी 31 मई को एक ड्यू डेट है ITR 2020 की, क्या ये भी उसमें एक्सटेंडेड मानी जाएगी?
सर आइडियली इट शुड बी,
है ना?
Ideally it should be, but department has not accepted it because before 3 days back they have issued a circular only accepting the same for the appeals time limit. They have not accepted for the ITRs. But if that goes, then the time limit for passing the assessment order will be shifted from 30th June to till that time. They are also making it applicable. Okay, the assessment has to pass in that within time limit.
Yeah. Then Subhajit Sahuji, sir, NGOs do not get transactions based internet banking, and PF is to be mandatorily paid online.
Sir, this is the practical difficulty. So kindly make the payment of by the check within time limit so that it cannot disallowed.
Yeah. Then Aryanji, notice under section 148 has been issued in the name of deceased assessee through its legal hire. However, permission under section 151 has been taken in the name of deceased assessee without mention of legal hire. Can I argue that notice under section 148 is invalid since approval is taken against deceased person?
Aryanji, from Oja ji, you can take my number. There is a case law on that. I can give it to you. As of now, readily not available with me. On a similar case, you can argue it.
Yeah,
100%. This notice, this reason is challengeable.
Yeah, lot number of members are appreciating Rakesh Ranjan Singh ji, Mayank Surana ji, Sudeep Jain ji, Arun Dubey ji. Everybody is Prateek ji, Aman Tuteja ji, and then Subhajit Sahu ji is telling that how can they pay in such a case? NGOs cannot even make advance payment to staff.
So because this is a statutory payment, this is not advance payment. So they can go to their bank and ask them to make the direct payment.
Yeah. Right. And Puspanjali Tripathi ji is also appreciating the session.
राजीव जी थोड़ी क्वेरी है.
शिवांगी जी.
राजीव जी.
जी सर.
जो असेसमेंट ऑर्डर आए हैं पीछे जो DSC लगा होता है उस पे लगा होता है नॉट वेरीफाइड, तो ये वैलिड है?
सब वैलिड है. आप because once if you will connect, once you open that file first time, it will ask you आप अपनी security settings, you just change your security settings of the Adobe, and then it can come as a verified. Because how the decentralization works, it works on the private and public key. They have provided you the private key in the DSC. Public key is available in the domain. You connect with your internet, make the settings change in your PDF software. It will be verified.
It will be verified.
Sir,
अच्छा एक और है, डिमांड ऑर्डर जो है वो ड्राफ्ट ऑर्डर पोर्टल पे नहीं आए, मेल पे आ गई है, तो ये वैलिड है या आना चाहिए पोर्टल पे?
All the communication has to be through the portal only. The
Portal only.
Rule says.
Okay.
Then Amol Chimarka ji from Bokaro, my very good friend. CPC call center is not working since long.
Sir, CPC is working on it from 1st of June to 7th of June. The income tax portal will be down. All the members are requested to know that they have downloaded all the notices. If any due date is there, they should submit a download application or submission. They are changing it. They are, first of all, they are doing the modernization of the call centers, connectivity to the department. So on the 8th of June, we will see that what is available in the portal now.
Yeah. Then Aryant Chatterjee, notice under section 148 has been issued in the name of deceased assessee. Already answered.
This is done, sir.
Then Manish Mehta ji, sir, in the case of my client, we have filled our reply well before passing the order, but they have passed the order under section 144 of Income Tax Act, also on return income, but also they issued the notice under section 274. Also, how to deal with this?
Sir, first of all, we have to see that what is the reason for passing the order in section 144. Then we can decide the next course of action.
Yeah. Then Atul Agrawal ji, sir, in what circumstances an appeal can be filed without paying any amount against the previous order? Please also clear how much demand to be deposited before appeal.
Sir, the law is very clear in this regard. The amount as per income tax return has to be deposited before going for the appeal. If there is any addition, I can go and file the appeal. And after filing of the appeal, but within a 30 days time, I should file a stay application. Then the AO can direct to file me for payment of 20% and grant me the.
Yeah. Then CA Yatish Gupta ji and CA Devendra Bhatija ji is also appreciating the deliberation of CA Rajeev Ahuja ji. So I think we are running short of the time. Shivangi Goyal ji is asking, sir, we applied for 12A for a client after 1st April 21 and we received a mail that provisional certificate shall be issued shortly. But on portal, there is nothing, no proceedings can be seen. What to do, sir?
I can't do anything. Wait and watch.
Right.
It's a one-way communication.
Yes. Right. Then Naresh Soni ji, Kalpana Sahu ji are appreciating. Then Chandan Sethia ji, sir, I filed defective return for assessment year 2021 on 10th May 21, but the return is not processed. Last date of filing return is 31st May. What should I do?
Sir, because I already replied and rectified the defects, so it will be processed. I should wait and watch.
Yeah. Then Vikas Goyal ji is also appreciating the efforts. Pankaj ji is also appreciating the efforts. And if we ask staff to pay and they don't have much funds, then we have to give advance to them to pay. But under Foreign Contribution Regulation Act, advance is not allowed. Subhajit Sahu ji.
Sir, this is again, I will request, this problem we face practically, then we approach the bank and ask them to kindly make the payment online from my bank directly. So that type of arrangement can be made.
Yes. Then Sandeep Jain ji for opting section 115 BAA Form 10 IC has been filed in December 2020. That is before extended due date, but CPC has denied it.
Sir, if this order is appealable, then I should file the appeal, or otherwise I should seek the writ jurisdiction to make it. If the order is not speaking and all the reasons cited, it will completely depend what the facts are. What is the reason for denial?
Yeah.
A blanket denial is not valid denial. It can be argued and taken with the higher authorities. Yeah.
Then Shiv Kumar Chaudhary ji, TDS credit claimed in ITR as well as showing in 26 AS. In assessment order, TDS credit not given. In appeal, addition by AO deleted, but no mention of TDS, neither allowed nor disallowed. Now AO has given appeal effect without TDS credit and raised demand. What is the recourse available? Appeal has been passed 4 years back.
First of all, whether I have taken the ground for not allowing the TDS is the question which need to be seen. Adjudicate all the grounds. So it will depend upon the facts of the case. What is the next course of action?
And then CA Gopilal Kumawat ji is also appreciating the deliberation, and Pawan Diwani ji, the AO has made additional under section 69. However, the tax is not charged under section 115 BBEE in the computation. What will be the consequences?
So you are very lucky. The consequences, he can rectify the order under section 154.
Yeah, very true. Then Nitin Pandey ji is also appreciating. And Chandra Sethia ji, I have raised refund reissue request by times, but refund had not given by department. The reason of failure of refund is PAN not linked in assessee bank, but PAN is linked with bank. What should I do?
So raise the grievance stating all the facts. Hopefully the refund will be issued.
Yes. And then my very good friend Amol Lakshimarka ji for Bokaro. Sir, there is complete lockdown in our state till 3rd June. How we can do our pending works having time limit of 31st May?
What to say? We have to be ready with the
मोदी जी के छोटे भाई बैठे हुए हैं, नरेंद्र ओझा जी, काली दाढ़ी वाले, ये बताएंगे, ये भी नरेंद्र हैं, ये भी दाढ़ी वाले हैं, तो ये बताएंगे क्या करेंगे, कैसे करेंगे, किस तरह से करेंगे.
देखिए, वो पूरे कंट्री में कहीं ना कहीं स्टेट्स वाइज एक लॉकडाउन चल ही रहे हैं. एक स्टैंडर्ड इंस्ट्रक्शंस स्पेशली इनकम टैक्स में आ जानी चाहिए जो सभी पे एप्लीकेबल हो, क्योंकि प्रैक्टिकल प्रॉब्लम है ये.
Yes.
With the not only our fraternity, with the client level also. क्योंकि लॉकडाउन में आपको इन्फॉर्मेशन ही नहीं मिलेगी तो हाउ टू फाइल द ITR, TDS returns and other details.
Yes.
How to file GST returns.
Yes.
There are many problems. Practical problem.
Yes. Then Rajiv Jhaji, Tinku Jain ji, everybody is appreciating the deliberation of Rajiv.
Anuj sir.
हाँ सर, बताइए सर.
Sir, there is a question asked by Mr. Sushil Jain on YouTube. Can I take that question, please?
हाँ, please.
Sir, Mr. Sushil Jain is asking, how can we claim old refunds for returns not filed for assessment year 2014-15? Procedure under 119 (2) D.
Sir, that is a petition filed before the authority. So you can file your petition citing the reason for not filing within time and giving the genuine difficulty and not unjust punishment. So the petition may be allowed, but that application has to be filed. And if you go on your income tax portal and you will select the earlier years, and in those years, if the notice under section 147, 153A are not coming, then they ask for 119 application.
Right. Thank you. And CA Nitin Pandey ji also appreciating the efforts of the organizers in arranging this webinar. CIT appeal called a remand report from assessing officer before faceless regime. Now what will be position and who will give remand report? AO saying he is not aware who and how remand report will.
It is the responsibility of the appellate unit to send the notice to the concerned person from whom they want to take the report. Yeah.
So I think now we have to conclude. I'm really grateful to Advocate CA Rajeev Ahuja ji for the nice deliberation and responding the queries in a very, very quick manner. Hundreds of queries, I think, have been responded. So we are really indebted to Rajeev Ahuja ji and Jawahar Park CP Study Circle, Syam Agrawal ji, Narendra Oja ji, CA Rakesh Vasne ji, and entire team and all the honorable delegates who are present with us. Still, more than 500 delegates are there on the Zoom and YouTube. So thank you very much. And may I request CA Narendra Oja ji, our Deputy Convener, for the vote of thanks.
Thank you, Anuj ji. Thank you, Rajeev Ahuja ji, for a wonderful deliberation and your wonderful question answer session between Anuj Goyal ji and Rajeev Ahuja ji. And thanks all the participants for this presenting and hearing all the deliberations of Rajeev Ahuja ji. Thanks a lot to the members. Thanks to all Anuj ji, Shyam ji, and Rajeev ji. Thank you very much. Good night. Thank you very much.
Thank you. Thank you very much. Thanks a lot. So, thank you, Rajeev ji. Thank you, Shyam ji. Thank you, Ahuja ji.
Thank you, Anuj.
And thank you, all our honorable viewers. I will request once again to all our honorable viewers to please take very, very good care of yourself and your family members. Please get yourself vaccinated at the earliest, because the number of cases are coming down, but you never know. Every day, still we are getting some bad news from our fraternity only. So please take very, very good care of yourself and your family members. Thank you very much. Thank you, Rajeev ji. Thank you, Shyam ji. Thank you, Narendra ji. And thank you, all our honorable viewers who have very, very actively participated in our deliberations. Narendra Chitrangia ji want to ask something very quickly. If you can unmute and ask. And Asutosh Sharma ji also want to ask any query. Asutosh Sharma ji, Narendra Chitrangia ji, you want to ask anything? And Suresh Agrawal ji, the chairman of Raipur branch, he also want to ask any query. Suresh Kumar Agrawal ji, please unmute. Narendra Chitlangia ji, you unmute please. Asutosh Sharma ji, you can please unmute. So I think we have to conclude. Some technical problem may be there on their part. So thank you very much, and we look forward to have Rajeev Ahuja ji in more and more programs and wonderful learning, I think, today evening. Thank you very much. So nice.
Thank you. Thank you. Thank you.
Thank you, ji. Thank you very much. I think we can end the meeting.